So thanks first of all for having me here today. It was an idea that I proposed to Christophe, and Christophe gladly accepted to share some information with the IPA candidate countries on some topics which we think are important for the candidate countries. And I took some time maybe to organize this session, but we are here today, so I'm glad that we made it. Mainly the three bodies that we will deal with and I will present today are the NOBOs, notified bodies, the DBOs, designated bodies, and ASBOs for risk assessment. The content of today's presentation is summarized in these 5 points. We will have an introduction on assessment bodies. Then I will present the difference between accreditation and recognition for these bodies. And then we will present a little bit more in detail the three different types of bodies I just mentioned: the notified bodies, designated bodies, and assessment bodies for the CSM on risk assessment. So the first point on the introduction on assessment bodies. First of all, what is conformity assessment? As I said as I told Christophe, I don't know the level of knowledge of these topics for you, so I really try to make it as simple as possible, starting from the definition of conformity assessment. Conformity assessment is the process carried out by a manufacturer to demonstrate whether specific requirements related to a product, a process, a service, system, person, or body have been fulfilled. A conformity assessment body is the body which is in charge of checking that the requirements are met by the bodies above for the products, a process, or a service. And this includes also activities like calibration, testing, certification, and inspection. We have some reference here to the regulation. The regulation of reference for these activities is the 765 from 2008, and also the Interoperability Directive Article 2. It's the point 42, which gives, I think, a definition of conformity assessment body. The abbreviation is CAB for us, so when I use CAB, it means conformity assessment body. And the same approach is valid in all regulated sectors of the European industry. So the conformity assessment is not only in the railway sector, we have it in medical equipment, ships, toys, gas emissions, and so on and so forth. I will show you in my presentation also the website of the Commission, where we have some information on these conformity assessment bodies and the directives which are in the scope of assessment. Just to give you an example, medical equipment or the toys are important and need to satisfy requirements in EU legislation. Who checks that these requirements are met? It's the conformity assessment body. So it's a very important task which safeguards the users, the final client, that products are meeting the requirements which are in EU legislation. And I think this is something typical, or it's really something specific of the European Union. We have some very strict requirements, often much stricter than in other countries. An example is on food, for example, on meat, where in the US, we know in some countries it's allowed to use hormones or other things. In the EU, there's more stringent and more strict requirements that ensure the health and of the citizens. But we need, of course, bodies. We cannot rely on the industry to certify themselves that what they produce is conform and it is complying with the requirements. We need some third-party bodies that make these checks. In the railways, so the railways is one of the sectors which is regulated, and we have this process of checking that requirements are met. And we have the three bodies that I mentioned before that are checking the requirements which come from different legislations or from different frameworks, legal frameworks. The notified bodies are mainly responsible for checking the requirements which are in the TSIs, in the technical specifications for interoperability. So that's their scope of activity. Then we have national technical rules. Every member state may have their own specific requirements because of the specificities of their territory or because of other reasons, because of weather conditions. They may have some more additional requirements, and these are checked by designated bodies. I make the example of my country in Italy. It's a very mountainous country. We have a lot of tunnels, and we have some additional requirements for the safety in tunnels, which are concerning fire protection and fire suppression. So for Italy, there are some national technical rules which must be complied with when building tunnels, or even must be complied by the rolling stock, which has to operate in these tunnels. And so we have designated bodies that check these national technical rules. Then last but not least, assessment bodies. They perform the risk assessment under the CSM regulation, which is the 402 from 2013. I will go less into the details of the assessment bodies because there's a colleague which is dealing specifically with that, and maybe we can organize one day to have a presentation just on the ASBOs, which is quite a complex domain. I can give you more information on notified bodies and designated bodies. Now let's say some words about notification, accreditation, and recognition. What are these three? What do these three words mean? Notification, and I take here a definition which you can find on the website of the European Commission, is an act whereby a member state, so member state we're talking about EU member states, informs the Commission and other member states that a body which fulfills relevant requirements has been designated to carry out conformity assessment according to a specific directive. Notifications of notified bodies and their withdrawal are under the responsibility of the member state. Now, it's not only European member states that can notify these conformity assessment bodies, but it's also other countries which have mutual recognition agreements, MRAs, with the Commission, and the EFTA countries. EFTA countries are those which include Norway and some other countries which are not now, I don't know in legal terms what is the correct definition, but they are not officially members of the EU, but they participate in the trade agreements and commercial agreements. So EFTA countries like Norway, they also notify, they may notify conformity assessment bodies. And the NOBOs, which are notified to the Commission, are collected in a database. This called NANDO, the New Approach Notified and Designated Organization. NANDO includes the identification number of each NOBO as well as the task for which it has been notified. Now, just to give a little break and not to just present a PowerPoint presentation, I will show you a little bit how NANDO looks like. I've put some hyperlinks here for those that are not familiar with the website of the European Commission. It's eceuropa.eu. And then if you navigate through it, you will reach this page on notified bodies here, notified bodies NANDO. And you have a brief introduction on the new approach new approach of NANDO, new approach notified and designated organization. And here you can select by country, by legislation, by body. And as I said, we are interested in the legislation on railways, which is the Interoperability Directive. But as you can see here in the page legislations, you have a lot of directives. These are all directives for which there are notified bodies which verify requirements which are in these directives. As you see, there's medical devices, hot water boilers, safety of toys. There's really a lot of domains, but the one we are interested in is railway domain, the interoperability of the railway system. So by selecting this directive here, we have all the bodies which have been notified to the Commission to perform the checks that I said of the requirements which are in the railway legislation. And here we have at the moment 57 notified bodies listed for the different countries. I can put them in order here. And you see that one country can have more than one notified body. A notified body is not unique per country. There can be more, there can be competition amongst notified bodies. And we have some countries that have four, five, six. Italy, I think, is the one that has the most, has 6, and so on. And as I said, there's also some countries which have an MRA, a mutual recognition agreement, like Switzerland, which have notified one body. So it's clear what notification is about. Member states have to inform the Commission about these bodies, and they inform also the other member states. Now we go to how do you notify? What is required to notify a conformity assessment body? There are 2 paths that can be followed for a conformity assessment body to be notified. There's either the accreditation path or the recognition path. Accreditation means that a national accreditation body makes sure that the conformity assessment body meets requirements that are set out in harmonized standards, and where applicable, also additional requirements that are set out in sectoral schemes. This is to carry out specific conformity assessment activity. So this is via accreditation. I think in your country, I would then after this slide, I would ask just for a brief feedback from some of the participants, just to tell me if you are aware of the national accreditation body which is operating in your country. Then as an alternative path to accreditation, we have recognition. This term recognition is not defined in the legal framework. However, in Regulation 765 allows that a member state selects directly a specific CAB that it verifies that it complies with requirements that are comparable to those CABs that are accredited, so the ones that we saw in the first path, to be notified. So in this case, we are not, the member state does not require that the conformity assessment body is accredited, but they verify directly. They carry out an audit or several audits of the conformity assessment body, and they ensure, they take the responsibility to ensure that the body is complying with the requirements which are in the relevant legal framework. Now, member states may choose accreditation, recognition, or they may accept both. It's not either or. It's not that if you choose accreditation, you cannot have recognition and vice versa. We have member states that allow both accreditation and recognition, but they set out a clear process for conformity assessment bodies for both accreditation and recognition. So as I said before, I would be interested in knowing if the states you are representing have accreditation bodies. And the accreditation bodies, I'm not sure they are under NANDO, but I think they are. Here, accreditation bodies. So maybe I'm asking a useless question we have here. No, I see those from the EU member states, and I see those from third countries. So that would almost answer my question that unless they are not listed here because your countries are not EU member states, but do you have national accreditation bodies in Serbia and Kosovo and Montenegro and so on? I go to the...
Yes, of course.
Yes, Milan.
Yes, we have a national accreditation body in Montenegro.
So which country, sorry?
Montenegro.
Montenegro, okay. Are there any other hands raised? Don't be shy. Another Milan, yes, from Serbia.
Okay, thank you. Yes, we do have a national accreditation body in Serbia, but the railway interoperability law allows accreditation and also recognition by National Safety Authority. So far, we do not have notified bodies, but we have two designated bodies which are recognized by National Safety Authority. Unfortunately, none of them covers all subsystems. So since 2013, when the Railway Safety and Interoperability Law entered into force, which was harmonized with the relevant safety and interoperability directive of the third railway package, there was no other solution but that the NSA, Directorate for Railways, to act as a designated body. Fortunately, 2 years ago, two designated bodies were recognized, and as I said, they do not cover all subsystems.
All subsystems, yes.
All subsystems, sorry. So for the Directorate for Railways act as designated body for the vehicles, all vehicles except freight wagons. This is the current situation.
Thank you, Milan, for this, for your intervention, because it allows me to specify that notified bodies, as you say, they can operate and they can be notified in the scope of 4 different subsystems. The 4 different subsystems are infrastructure, rolling stock, energy, and CCS. And of course, this depends, it's very important because they need to have the competences in the different fields to be able to assess requirements in these 4 subsystems. So if you're notified for the CCS, we have to make sure that the personnel in the NOBO has expertise and the skills and the competence in the CCS domain.
Let me take the chance to add that I've read in the chat that a colleague from Turkey contributed that the Turkish accreditation agency, TÜRKAK, is the national accreditation body.
Yeah, I know about Turkey because TÜRKAK is part of EA. EA is the European Cooperation for Accredited Bodies. It's like, yes, it's a European association which coordinates the accreditation bodies. And of course, it's not limited only to the accreditation bodies which are established in the EU member states, but also in other countries. So I knew that Turkey has an accreditation body. I hope everything is clear on the accreditation path and recognition. In one case, it's national accreditation bodies that take the burden to verify that the conformity assessment bodies meet the requirements which are in harmonized standards, and we will see which standards are of interest for the railway sector. Then the other path is recognition, where the member state takes on itself the responsibility, the role of checking that cabs meet the requirements, the relevant requirements. National accreditation bodies is the sole body in a member state that performs accreditation with authority derived from the state. There's just an example here of Greece, okay, but we saw on the website of the Commission that you have all the list of member states where there's an accreditation body. So the accreditation body is unique per member state. There may not be more than one accreditation body per member state. It's one per member state. What is a harmonized standard? A harmonized standard is a European standard elaborated on the basis of a request from the EC to a recognized European standards organization, which is CEN, CLC, ETSI, to develop a European standard that provides solution for compliance with legal provisions. The harmonized standards which we are interested in are the ones in the series 17,000. And more specifically, 17,065 is the standard for the certification of products. And that's the standard we require cabs that work in the railway sector to comply with. A sectoral scheme, as was also presented in the previous slide, is a scheme that has been developed for specific sectors to add some additional requirements on top of the requirements in the harmonized standards. It's important to refer to these sectoral schemes because in the railways we have a sectoral scheme which is providing additional requirements to nobles that want to be notified for the interoperability directive. And the sectoral scheme that exists is in this case, the scheme owner is the agency. We have developed the sectoral scheme and we are right now in the revising it to update it since 2017 when it was adopted. Is there anything else to say on the standards and the sectoral schemes? Why the need for sectoral schemes in railways? Because of course you know that in railways the requirements in railways are much more detailed than in other fields. On top of the directives of the safety directive and the interoperability directive, we have some secondary legislation, which are the TSIs, which are giving even more detailed requirements for railway products, whether they are interoperability constituents or subsystems. And so for these additional requirements, we need some additional, we have to mirror that on the noble side to have nobles that have the skills and the competence to verify these additional requirements. And so also from the noble side, we need that the notified bodies are qualified to carry out these checks. And how to qualify the nobles for the railway sector? We qualify them with these additional requirements that are in the sectoral scheme.
Jean-Paul, I think there is one colleague, Milan, who would like to ask a question or to make a remark, please.
Actually, it's not a question. I have to correct myself. What I said about recognition of assessment bodies was wrong. This applies to us both. Ministry of Transport is in charge for nomination of conformity assessment bodies, not the Directorate for Railways as National Safety Authority. Thank you.
Okay. Thanks for the correction. If there are no other questions, I go to on the slide on why accreditation recognition exists. And we will have here a triangle of roles and responsibilities just to explain a little bit where responsibilities lay for manufacturers and why we call them first or second or third party. So the manufacturer or service provider is the one that is building the product or providing a service. They are usually referred to as first party. They may, as I said, check their own products, and they may also attest or certify on their honor that a product is built or service is provided according to the requirements in the law. But of course, for some sectors where the safety of citizens is concerned, first-party assessment is not really the one that ensures that the safeguard of customers is ensured. The end users, which are the clients, the consumers, which is us, in the case of trains, the passengers, for example, are called second party. And the third party are conformity assessment bodies, which are and which should be independent from the other two parties. So when we say third party assessment, we mean an assessment which is carried out by a body which has no financial or commercial interests with the other two parties. And this is to ensure that they can assess with freedom that requirements are met by the manufacturers. The first party, a manufacturer, will apply to a conformity assessment body to have its product or its service checked, assessed. The conformity assessment body, the NOBO in our case, issues a certificate with a report attached to confirm or even well, if they reject a product, then they don't issue a certificate, but they will issue a report saying that a product does not conform to the requirements. But let's say that everything goes fine. If everything goes fine, the conformity assessment body will issue a certificate to the manufacturer. The manufacturer uses this certificate and this report to issue other documents to the consumers and to the end users, to the authorities. I can make the example of a vehicle authorization, where an applicant will use the certificate for its application to the NSA or to the authority which is in charge of issuing vehicle authorizations. And they will provide a series of documents, amongst which the certificates which were issued by NOBOs. No contractual relationship between the NOBO, as we said, with the second party and also with the first party. It's mainly a technical activity, and it's mainly from, or it can be from another country too. Distrust may come from technical barriers. Well, no, the distrust may give way to technical barriers between member states or between specific business parties, and an increase in costs. So to avoid the increase of cost and technical barriers, the accreditation bodies ensure that the assessment carried out by different conformity assessment bodies are the same and are harmonized. How to ensure that across Europe all accreditation bodies act in the same way and that all the NOBOs are assessed in an equal way. And this is by accrediting the conformity assessment bodies to a unique standard. Once the conformity assessment bodies is accredited to, in this case, the standard 17065, we have the confidence that all NOBOs are equal or should be equal in their assessment and in their competence to assess the requirements in that specific domain. This confidence will build mutual trust, and in the end will also facilitate commercial activities across Europe. Because one thing I didn't say is that a NOBO may operate not only in the member state where it is established, but may operate in all EU member states. So noble, we saw that we have nobles in Austria here. I go back to the previous. A noble which is established in Austria may be contacted by an applicant which is as far away as Latvia to assess the requirements of a product to show that it is conform to the TSI. And how is this possible that a noble in Austria can assess in all European countries? It's because all the nobles have been assessed in the same way by the accreditation bodies. And that is according to the ISO standard 17065, plus the additional requirements of the air assessment scheme. Where nobles are not accredited, and we said the member states recognize, we check that the member states that recognize follow the same requirements that in the end nobles that are accredited have to comply with. So in the end, recognized and accreditation bodies are competent in the same way. And this allows that across Europe, all nobles may carry out the work. It creates competition, so it also creates competition on prices. So in the end, the costs, one of the objectives is to lower the cost of assessment, and in the end also of railway products. The triangle of roles where there's the first party, second party, third party. It's important to get familiar with this terminology, third party assessment. When we're talking about third party assessment, it's always the assessment by an independent body from the two other parties. And as I said, in railways, where the safety of passengers and the safety of the community is concerned, it's very important that the requirements in the TSIs are verified and that they are met, and to make sure that there is no collusion, that there are no economic interests in the assessment of these requirements. Third-party bodies are called upon to make these checks. And in fields where there's less concern maybe for safety, you may have first-party assessment or second-party assessment, but not in railways. Now we go to the specific of notified bodies, which is the domain I'm more competent in. The nobles in the EU, as I said, are listed in NANDO, and as of March 2022, we had 57 nobles, which are notified for the interoperability directive. So it's not 57 nobles across all domains. It's just for the railway domain in the interoperability directive that we have 57 nobles. Their scope of activity is the whole territory of the European Union. And now you're more familiar what does it mean accredited and recognized. We have 45 nobles which are accredited and 12 nobles which are recognized. For those that are more interested in knowing which countries are recognizing, it's a minority. And I would say 90% of the EU member states, they accredit their nobles, but we have Germany. We have then Hungary. And if I'm not wrong, Slovenia, which allows both. Slovenia allows both recognition and accreditation for a cab that wants to be notified. But for Hungary and Germany, they recognize their nobles and they don't require accreditation to the ISO 17065. All other countries, they ask their accreditation bodies to first accredit a cab. So the cab must hold an accreditation certificate before it even applies to the member state to be notified to the Commission. And this is one check that we do. I take, for example, this noble from Italy. which is, in this case, it's a noble which is notified for all these legislations, but in particular for the Railway Interoperability Directive. If we take their notification document, we see that they are accredited for the ISO standard. And they are accredited by the Italian national accreditation body, which is Accredia. Of course, nothing forbids that they could be accredited also by another accredited body in another member state. This is because the ISO standard is unique, is the same across the EU. So any other accreditation body may have accredited this noble, RINA, for this 17,065 standard. And since we are at it, we see that this noble is accredited for the 4 subsystems in the railways: infrastructure, energy, CCS, and I'm sure rolling stock too. So the 4 subsystems which are in the railway domain are in the notification of RINA. So we go back to the slide. Yeah. So as I said, 45 accredited nobles, 12 recognized. The accredited nobles have been assessed according to the ISO standard plus the error assessment scheme. Recognized nobles, it is the role and responsibility of the member state to check that they comply with the requirements in the IOD, in the Interoperability Directive, plus the error assessment scheme. There is no, it's in red and it said recommended because we cannot oblige member states that recognize their nobles to apply the error assessment scheme. But as a best practice, Germany, Hungary, and Slovenia, all 3, they have as a mandatory condition that the conformity assessment bodies also satisfy the error assessment scheme. And sometimes they also, sometimes they also put as a prerequisite that they comply with the ISO standard. So although they recognize, they are in, we could say they are in somehow they are requiring both the accreditation because they put as a prerequisite that they are accredited to the ISO standard, and they also put the error assessment scheme. So this ensures that harmonization and that mutual confidence across Europe, that recognized nobles are treated in the same second-class nobles. And I want to make clear that accredited nobles are not better than recognized nobles and vice versa, because there is sometimes this belief that accredited nobles, because they go through all the accreditation of the ISO standard, they are more serious and more competent than the recognized one. That is not the case. And to make sure that this is not the case, we have, like, let's say, the activity in which I am involved in is to check that the recognized nobles and accredited nobles are competent in the same way. So recognition, as I said, in recognition, it's we have non-accredited conformity assessment bodies unless the member state requires as an additional requirement that the CAB is accredited. And the member state is, as we said, choosing the recognition path for notification. In accreditation, it's a little bit more structured, the whole framework in accreditation, because we have this association, European Cooperation for Accreditation, which supervises all national accreditation bodies, including those from countries which are non-European countries like Turkey. I think there's also Morocco, there's Algeria, because I've seen the acronyms of Algerac, which is the Algerian accreditation body. And so EA really collects all the accreditation bodies wherever they exist. And the accreditation bodies, as we said, they accredit the conformity assessment body, which applies to the member state for notification. Under this dotted line, once you pass this dotted line, it says here, the CAB becomes a noble. The CAB, let's say, is promoted to become a notified conformity assessment body. Let's say that here is before promotion, everything that is up here. Then they apply to the member state. The member state notifies to the commission. Once this notification is accepted, because there is a period of 2 weeks for the credit for the accredited nobles and 2 months for recognized nobles, where other member states or anyone may appeal the notification and may say, I'm not sure that this notified body is qualified, and give evidence or ask for more evidence. So they may oppose or they may ask for additional clarifications. But once this period is over, a CAB is notified, officially notified in the Commission's database. And I think the notifications last 4 or 5 years. The 5 years is also because the accreditation certificate usually has a duration of 5 years. So once the accreditation certificate expires, in theory, the noble must be suspended from the database of the Commission. And what are these 1 and 2 that we will see now in the next slides? The 1 and 2 is 1 refers to the accreditation scheme, which harmonizes the several ways the EU has to apply EN standards. And as I said, the accreditation scheme is specific to railways. It adds very specific requirements on competence of the noble and of its personnel, which are required in the railway domain. And in 2, we have the procedures. Procedures with which nobles may carry out their assessment of products and of services. Okay, here there's the scope description of the accreditation. There's this arrow connecting here. This, what you see here is the accreditation certificate, this A with it's like a label. Nobles, they required accreditation to have this certificate and to say we have formally been accredited and we have a certificate that certifies that we are responding to the requirements of the accreditation. And the scope of the accreditation has to be the same as the scope description in the notification to the Commission. So now let's go further into the details of 1 and 2. The sectoral scheme for nobles that, as I said, the agency developed, and the agency is the scheme owner, was developed in 2017, and it goes formally under the name of ERA Technical Document, and it is published on our website. I click on the link just to show you. Okay, this brings you directly to the document, but if we want to start from the agency website, I go to the home page here. Under activities, we have different activities. The TSIs are maybe of more familiarity for you. And we have conformity assessment, which is the topic we are dealing with today. And under conformity assessment, you have some general information, as we said, reference to third-party independent conformity assessment, which hopefully you know now what is third party compared to first and second party. We have a guidance document, the legal framework, and the decision, which I was saying, to the ERA assessment scheme, which adds some requirements for the nobles to comply if they want to assess railway products. And it is this document, this technical document here. I'm not going to go into the details of the document, just to show you that this document, if we go to one of the technical requirements, for example, this requirement here has to be added on top of the requirement of the ISO standard 17065. So at this point here, we have to add that the evaluation of the sufficient number of personnel shall be produced in writing. So all these things that are said here should be added are requirements that are needed to nobles that want to operate in the railway domain. And there are quite a few of these requirements. Also in terms of competence of personnel, we have at the end some annexes concerning, for example, the tech. Here, let's take one that is decision maker. We have here some requirements that are nowhere in the ISO standards. In the ISO standards, we will never require that a staff member of the noble should have a master's or a bachelor or relevant technical vocation, that they should have knowledge of the interoperability directive, that they should have knowledge of the railway modules, of the railway safety directive, of the TSIs, and so on. So as you see, there are a lot of additional requirements which it was deemed was necessary for the nobles in order to ensure that they would assess in a competent way that products were conform to the TSIs.
Excuse me, there's a question from a colleague in Turkey. Can a non-member state notify the EU, for example, a body which is accredited by Turkak?
Yes. I need to go back to the website of the Commission, where we see here on the mutual recognition agreements. As I said in a previous slide, let's see if I can find it quickly on the mutual here. Member states and other countries with which the EU has concluded mutual recognition agreements and protocols may designate nobles per directive and make the information available in NANDO. So there is you need to have these mutual recognition agreements. And the mutual recognition agreements, if we go under the website of the Commission, we see that there are several member states that have them. We have, for example, Switzerland, and that's why we find one noble which is notified by Switzerland. In the case of Turkey, I don't see Turkey in having a mutual recognition agreement. So even if Turkey accredits a conformity assessment body in Turkey, and this body may not be notified to the Commission. So it may in fact not operate, well, it may do assessments, but these will not be officially recognized by in the EU. Let's say that in Turkey there is a conformity assessment body. They will assess a railway product, but they cannot issue an EC certificate. They will issue a certificate, but this certificate will not be recognized by other nobles or by other authorities in Europe. Let's say they issue a they issue a certificate for wheels, railway wheel. They will not be able. An applicant will not be able to apply for the authorization of a wagon using that wheel in the EU, because that wheel needs to have an EC certificate. And the one issued in Turkey will not be an EC certificate, it will be just a simple certificate. Which in its content, I'm not discussing that it may not be equivalent to an EC certificate, but These are the rules in the EU. You need a EC certificate for a product to be placed on the market. Without that, you cannot place anything on the territory of the EU. I go back to my presentation. We were here on the ERA assessment scheme, which provides additional requirements, and the objectives of the ERA assessment scheme is to assess the technical capacity of nobles to properly perform their duties, and in the end also increase mutual trust, strengthen trust amongst EU nobles in the notification process. And I would add it tries to bring on a level playing field both recognized and accredited nobles. So there are not discrepancies between the two, and there is no distrust between recognized and accredited nobles. The ERA assessment scheme was endorsed by the European Cooperation for Accreditation in November 2017. EA made the ERA assessment scheme mandatory for all accredited nobles since 1st of July 2020. So to date, all accredited nobles must comply with the ERA assessment scheme. For the recognized nobles, as I said, for those 3 member states that I listed, Germany, Hungary, and Slovenia, all 3 of them require, although it wasn't an obligation, but they do require that the ERA assessment scheme is met by the nobles. And we have been since 3 years checking nobles across Europe, and okay, we audit them and we make sure that they comply with all the requirements in their assessment scheme. The scheme is based on the ISO standard 17065, which is the standard for product certification. In the standard 17065, we have, however, reference to other 3 standards for the inspection, testing, and the quality management approval certification. And these 3 standards are the 17020, the 17021-1, and 17025. 17020 is for inspection. The 21-1 is for the QMS approval. 17025 is for laboratories. So we have, for all 3 of these standards, we have some additional requirements which are listed in the ERA assessment scheme on top of those requirements, which are the, let's say, the basic ones of these 3 standards. In the 17065, there is also this mechanism to safeguard impartiality, which is very important to make sure that nobles keep their independence and are impartial in their assessment. The scheme is also based on the ISO standard 17011, in the possibility that nobles may have external experts from the NSA or from ERA based on the expertise in the specific field. The duration of accreditation, as I said, is usually 5 years, linked to overall cost. I don't remember the consideration when it was made on the cost, but every 5 years, accredited nobles must renew their accreditation certificate, and they go through a recertification audit by the accreditation body. Now the assessment modules. The assessment modules give procedures, the procedures for the assessment of products depending on the specificity of the product and on the needs of the manufacturer. These modules are listed. We have some generic modules which are listed in the decision 768 of 2008. And the choice of module can range from the lightest module, which is internal control of production. And I could say this is a first party assessment. That is, the manufacturer will make an internal control of its products. For simple products or products not necessarily presenting serious risks. And then we have more comprehensive and more complex modules, which will include also an assessment of the quality management system or of part of the quality management system of the manufacturer. And this is, you usually choose these modules for where there are more severe, the risk for more severe consequences if there is a non-compliance to the requirement. The Blue Guide 2016, which is also listed on the European Commission website, is a very useful guide that introduces you to the world of conformity assessment and gives you a lot of information on the new approach and all the topics that are related to conformity assessment. Now, as the modules, as we said, we had to develop additional requirements for nobles operating in the railway sector. The same reasoning goes with the modules. The modules which were which are in the decision 768/2008 are not specific enough for the railway sector to be used efficiently. The railway sector, as I said, has an additional layer of legislation, which are the TSIs. And for the TSIs, as they bring more complexity, we need more complexity also in the modules, or at least we need more specific related definitions of the procedures to use. And so also for the modules, we had to develop some sector-specific modules, which we call in our jargon railway modules, and which are included in the decision 713/2010. These railway-specific modules are divided in modules that are used for the assessment of interoperability constituents, ICs here in my slide, and subsystems, SS. The decision provides a menu of modules for railways that allows the legislator or the applicant to choose the right one in proportion to the level of risk and of safety which is required. In many cases, the TSIs, they specify the modules, or in all cases, I will ask for confirmation to Desi. I think all TSIs, they specify the modules that can be used or shall be used by the applicants. And we have in the TSIs, we may have different types of modules depending on what the applicant wants to achieve. Here's a table of the modules for interoperability constituents. They can be identified by the C in front of the generic letter, which is used in the generic decisions 768/2008. So in addition to the A, A1, A2, H, B, we have the C to indicate that they are used for interoperability constituents. The modules are in principle the same as the general modules, but they provide a little bit more detail on what has to be assessed by the noble. Then we have modules for subsystems, and the modules for subsystems, they have an S in front of the module. And as we said here, we can have more simple modules going to the more complex, which include also a verification of the QMS of the quality management system of the manufacturer to make sure that the quality management system considers the production of that railway product or is, let's say, adapted to the production and the assessment of the requirements of that specific railway subsystem. How to choose a module? We gave some indications before based on the severity of a risk and based also on the costs you may choose one or another subsystem. In this case, in this scheme, we have modules for subsystems, and there are two possibilities, as I said, to have the modules procedures with the quality management system check or without a quality management system check. Of course, one with a QMS check is more expensive to carry out. The NOBO will charge the applicant more to carry out an assessment with the quality management system approval. The choice of the module has an important impact on the cost and time. The choice depends on specific situations of each company and the characteristics of the products. There is some considerations that we can make that are very basic between fixed cost, mass production, marginal cost. As a rule of thumb, SB modules that we have here are for mass production, for example, for vehicles, where you produce hundreds and thousands of units, and SG for specific developments where you have a fixed installation, where you will not have a mass production of a railway line. So SB modules for vehicles, for wagons, for train sets, for locomotives. SG is more used for fixed stations, railway station, a overhead line, or a railway line. Designated bodies, it's very quick. Compared to NOBOs, they should, to be qualified as a DEBO, you should comply with requirements that are similar to those of NOBOs, but of course you have to change a little bit the scope, because DEBOs, they operate in the scope of national technical rules, while NOBOs, they operate in the scope of TSIs. So for DEBOs, there's this Article 45 in the Interoperability Directive, which says that they must comply mutatis mutandis with the same requirements as NOBO. So the same requirements, for example, of independence, of impartiality, competence of its personnel. Of course, the DEBOs should be competent and have competent personnel staff to assess national technical requirements. Also, DEBOs may be accredited against the 17065 standard. There is no obligation. This is it's a choice of the member state to decide with which requirements DEBOs must, if a DEBO must be accredited or not. The requirements are those of the IOD mutatis mutandis. But in addition to that, if the DEBO has to be accredited, this is the member state to decide. And the mutatis mutandis here is, for example, the detailed competence should be related to notified national technical rules. That's NNTR. Sorry for the acronym, but I think it's defined in another slide. It's the national technical rules of the member state, and not anymore to the TSIs. So these technical rules are specific for each member state, which makes that a DEBO is not a cross-border assessment body. A DEBO can assess in that member state because it has the competences in that for the national rules of that member state. A DEBO in Italy cannot be a DEBO in Finland. Or it may apply to be a DEBO in Finland, but then they will have to demonstrate that they have the competence in the rules, national technical rules of Finland. So it's not to say that they may not apply. They may apply, but then they have to prove their competence. We just saw the railway modules do not apply to DEBOs, although it's an option. It's free to the member state to decide or to apply the modules also to the assessment of national technical rules. And in many member states, the DEBOs, they apply the same modules that are used by the NOBOs. Also, the DEBOs are not monitored at the EU level. That means there's no harmonization or no peer review of DBOs across the EU. Maybe in the future there's no legal basis for this, so this is left really to it's something that is not mandatory, and it's on a voluntary basis to be monitored. Many CABs combine two or more of the following roles. They combine the role of NOBO, ASBO, and DBO. And we've seen this in our monitoring activities, that many NOBOs also, to cut under costs, they are sometimes they are all three. They are NOBO, ASBO, and DBOs. And so they must have personnel that are competent in the different domains. But just to say that the ASBOs assess according to the requirements which are in the CSM for risk assessment. So just to sum up, NOBOs are for the TSI requirements, DBOs for the national technical rules, and ASBOs are for the requirements in the CSM regulation.
I think we have one more contribution from Milan, and probably that's almost the last one, as the time is already over the initially planned 11 a.m. Please, Milan.
Okay, thank you, Christoph. Jean-Paul, will you be so kind to show on the screen the page 23 of your presentation about designated bodies?
Yes.
Yes, just this could be useful to some participants. I just want to say in a few words the practice that we apply here in Serbia. The requirements that designated body has to fulfill in regard of competence, impartiality, and so on are the same as requirements for a notified body. And in accordance with our laws and bylaws, the same modules apply to check conformity with national technical rules. So the only difference between DEBO and NOBO is what do they check? Compliance with TSIs or national technical rules? And one more question to you, Jean-Paul. As far as NOBOs are concerned, you, in your presentation, referred to standard 1765, a series of standard 1720s.
Yes.
Agency accreditation scheme and so on. But what about the requirements that conformity assessment body has to fulfill, which are laid down in the interoperability directive? There are maybe 20 pages about that. All these requirements concerning notified body are harmonized. Maybe is there any conflict between requirements laid down in standards and accreditation scheme and in interoperability directive? Thank you.
Yes, I will try now to put on the screen the interoperability directive, because we do have an article there that should answer your question directly.
Actually, a lot of articles.
Well, yes, there's a lot of articles for the requirements of NOBOs, but then there's one requirement that says that a NOBO complying with the harmonized standard is
okay. Maybe I missed it. Okay, but it is important that what is required by directive is also in line with the standards and agency accreditation scheme.
It's good. It's a good opportunity to show the other participants where in the interoperability directive we find requirements for notified bodies. So starting Article 30, Article 30 starts setting out requirements for conformity assessment bodies. One shall be established under national law, blah, blah, blah. And down to 31 is for the impartiality, so other requirements for the conformity assessment bodies. Article 32 gives requirements on the personnel, and I think up to Article 34, which gives requirements for subsidiaries and in the case of subcontracting of activities by the notified bodies. The article I think is important for us is this one here. And Desi, she has some legal background, so she may explain it better. But this article says that where a conformity assessment body demonstrates its conformity with the criteria laid down in the relevant harmonized standards, and in this case, the ISO 17065 is a harmonized standard, or parts of this standard, the references of which have been published in the official journal, it shall be presumed to comply with the requirements set out in Article 30 to 32 of this directive. So if you comply with the ISO standard 17065, this gives a presumption of conformity to the requirements that are in the interoperability directive in Articles 30 to 32. Of course, there's this sentence, insofar as the applicable harmonized standard covers those requirements. So going back to my slide, if you comply with this, how do you put it in slideshow? If you comply with the 1765, it presumes that you comply with the requirements which are in the interoperability directive. But on top of that, I must add, sorry, that you must comply with the 17,065 and now also the error assessment scheme. These are two musts or two shalls. Shall comply with the 17,065 and the error assessment scheme. Daisy, is there anything that I missed that maybe is worth saying?
Okay, thank you for the clarification. Just one more question. Is ERA accreditation scheme mandatory to apply or not?
It is for accredited nobles.
But for recognized?
It's optional for the recognized, but the experience we have seen, we have been to the member states that recognize, they have made it mandatory. So they have put it in national law that it's mandatory. Okay, so in the end, it is mandatory across all the EU member states.
Okay, thank you very much for the clarification.
Yeah, in one case, it was made mandatory by EA, the European Cooperation for Accreditation, and in the other case, it was made mandatory by the member state for recognition. And it may be useful if we have any authorities in the participants here that a first step maybe for candidate member states would be to apply the technical document, which is this here for the error assessment scheme, let's say, to start applying the requirements that are here, both for their depots and for the cabs that they think one day could become nobles. So if you already take this as a reference, and some member states, they do it also for the depots, they take this document, they adapt it, of course, because this is cut for nobles, but they adapt it, for example, for the staff. They require that the staff of a depot has to comply with the same requirements that are here. And this way it facilitates then afterwards that a depot may act also as a noble, and that especially that the depot is competent, because a depot that complies with all these requirements and has been assessed against these requirements will, well, I wouldn't say for sure, but it has more possibility of being competent than a depot that hasn't been assessed against any requirement. And I say this with knowledge that we have discovered one case of one member state which just designates depots just because the depot has made an application, but they do not assess anything in the depot. They don't assess requirements from the depot. Although, and here I go back to the directive, article, there is the article on DBOs, if I find it.
Well, the same requirements, except in a few cases.
Designated bodies here. Article 45. The requirements related to conformity assessment bodies set out in 30 to 34, and these are the ones we've seen for nobles, shall, so this is a requirement of the interoperability. It's not a choice, it's not optional, shall also apply to bodies designated under Article 15.8, which are the designated bodies. So designated bodies have to comply mutatis mutandis with due differences to the requirements to which also nobles comply. And that's why some member states have taken the air assessment scheme and they have just transposed it for the assessment of DBOs. And this way we are more or less sure that DBOs are competent as they should be. And this concerns the skills of personnel, documents to be kept. So this is giving a little bit a guideline for DBOs too. Not a little bit, it's giving guidelines to the DBOs. So if really, if there are equivalent to bodies, equivalent to the NSAs that are listening today to my webinar, I would suggest that they start looking at these requirements and they already start applying them to their DBOs. And I know Daisy wanted to say something before and she didn't have the chance. So Daisy, please, if there's anything you want to add on the harmonized standards and
well,
Article
I was
33.
going to give the short answer to Milan that the three documents of interoperability directive, error assessment scheme for the nobles and the standard are aligned. In order to implement the requirements of the interoperability directive about the conformity assessment bodies, the best way is to take ERA scheme, which is based on the standard 17065, plus some amplified requirements. These were done because this is a general standard. It's a bit generic, so we gave precision, for example, for the competencies of the CAPs on different subsystems, so it takes really into account railway specifics. So in order to implement the requirements of the directive, you need to apply ERA sectoral scheme. And then Jean-Paul gave more details.
Thank you, Daisy. Oh, and I guess that ends my presentation. If there are questions, I have put at the end of the presentation a slide here with a functional email address for you to contact us directly to have questions either on noble monitoring or on general questions on the conformity assessment bodies. And feel free to suggest also other topics which may be of interest for you, for the agency to give a presentation, to give a webinar.
So thank you very much, Jean-Paul. It's very much appreciated that you presented this morning. And I think colleagues also liked it. There were interactive parts where questions were discussed, and I liked it very much. Also, thank you to Daisy for being here this morning and to everybody else. I put the agency's website on the screen because I would like to invite all of you to register for our newsletter. You can go to the website era-europa.eu and here you find login. I won't click here because it doesn't work for me as I'm an ERA staff member. I cannot change my profile here, but here you are able to select your preferences for newsletter, and for the interest you want to learn about. You can alternatively, if you don't want to register for a newsletter because you receive already too many emails per day, you can also look yourself for upcoming events. And here, for example, I would like to mention the webinar on the 17th of May about maintenance. There's a series of other webinars coming up later this year. And if you have a look from time to time, I think you will find a topic which is interesting to you. Thanks once again also, Jean-Paul, that you offered the possibility to answer questions later on. If you forgot his email address, you can also use the email address which you found, or from which I sent the invitation, from which my colleague Adriana and I sent the invitation. I put it right into the chat as well. It's a bit shorter. I will also forward all the questions which are related to conformity assessment or the NOBO verification scheme to Jean-Paul and Daisy, if you have any. Yeah, I can only say once again, thank you to everybody, and repeat, please, if you have dedicated subjects about railway topics, please let me know. It may take some time to organize this because our experts are very much loaded, but hopefully we will be able to come back to specific questions and requests about webinars, and we will do it as soon as possible. Thank you for your patience, for overrunning as well. You know, railways are sometimes late. It also happened to us today, but I hope you enjoyed it, and I hope to see you very soon, maybe in person again. Thank you very much.
Thank you very